Greetings, creators. Greetings to the gods. Welcome back. Today we're continuing Commonwealth Caribbean Trust. Trust distinguished from debt. Trust distinguished from debt. The trustee-beneficiary relationship must be distinguished from that of debtor-creditor in that the obligation of debtor towards his creditor is personal, not proprietary. Thus, a creditor has no right to trace against a debtor. Thus, the creditor has no right to trace against his debtor. It means that when a creditor lends a debtor funds, the creditor has no interest in the funds that he lends the debtor. The only interest the creditor has is the return of the funds from the debtor. In particular, where a customer deposits money in a bank, the bank is not a trustee of the money, but a debtor. All right. So let us look up the definition of deposit. The act of giving money or other property to another who promises to preserve it or to use it and return it in kind. That's a deposit. All right. Let's see what the definition of depositor is. Depositor, one who makes a deposit. All right. So let us look up the definition of debt. So debt, sense one, liability on a claim, a specific sum of money due by agreement or otherwise. The debt amounted to 2,500. So that is a debt. Let us look up the definition of creditor. Creditor, one to whom a debt is owed, one who gives credit for money or goods, also termed debtee. That is sense one. All right, so that is a creditor, one to whom a debt is owed. Let us look up the definition of customer. One who regularly or repeatedly makes purchases of or has business dealings with a tradesman or business house. And when we look at the third sense of the definition, a buyer, purchaser, or patron. All right. So now, when we look at in particular where a customer, a buyer, purchaser, or patron deposits, and when we look at the definition of deposit, we see it's property that is to be returned in kind. Money in a bank. The bank is not a trustee of the money but a debtor. And the reason why the bank is not a trustee of the money but a debtor is because the customer or the depositor did not make his intent clear that he wants the specific money deposited returned in kind. So, for example, if you take out a hundred note out of your pocket, out of your wallet, look at it. You will see a serial number on it. That is a specific number that is that can identify that particular note. If you deposit that note into a bank and you tell the bank that you want that specific note back, that will be a trust relationship and the bank will be trustee. But if you deposit that note into the bank and all you want to get returned is the amount, the specific amount, which is 100 TT, then it wouldn't make a difference if you get 20 $520 notes or 10 notes. All that matters is you get the amount, the specific amount, and that is a debtor-creditor relationship. In Reed versus Grant, Watkins J.A. Acton in the Jamaican Court of Appeal emphasized that it is now settled beyond controversy that at common law, the relationship between a depositor and his banker is that of creditor and debtor, and that pursuant to this contractual relationship, the depositor holds the legal title to the debt or shows in action. So it is settled beyond controversy that at common law, remember, a trust is a creature of equity. At common law, we're talking about the debtor-creditor relationship. All right. At common law, the relationship between depositor and his banker is that of creditor and debtor. And the depositor holds the legal title to the debt, which is what we say could be an agreement, all right, or a shows in action. And a shows in action is what we term commercial paper or negotiable instruments or chattel. All right, that's a shows in action. That's how you pronounce this word. CHOSE. It pronounces as shows. All right. So as a creditor, the customer has merely personal and not proprietary rights against the bank. So when you deposit that 100 note, the bank is only obligated as debtor to return the amount. It doesn't matter if it's a complete note, 100 note, or 520s or 1010s. Or if you get another 100 note, it would not be the same because the serial number will be different. All right. So thus, if the bank goes into liquidation, the customer is not entitled to gain precedence over the bank's other creditors by obtaining a charge against money or other property in the possession of the bank. When you made the deposit, you did not create a security interest in any of the bank's assets. It was merely a simple contract debtor-creditor relationship that the bank is going to hold your 100 and return the specific amount to you, whether it be another 100 note with a different serial number or 520s or 1010s. This principle is illustrated by the Cayman case of Han versus Bank Intercontinental Limited. We have a footnote here. So this is one footnote here. This is another footnote here. All right, let me get my pen. So we have a footnote here, 19, and a footnote here, 20. So 19 tells you the year 1976. This case was 1987. All right. And these cases are very important. These cases illustrate the principles of trust. All right. Whether a relationship could be termed a trust or not. All right. So where by a deed of settlement, and remember, a deed of settlement is an instrument that is used to create a trust. The defendant bank was appointed trustee of a fund for the benefit of the plaintiff and members of his family. So the defendant bank, so the bank was before the court as defendant. And Han, this Han guy here, or this Han family, was the plaintiff. So they brought a suit against the bank before the court. The bank placed the fund in an interest-bearing deposit account with itself. So the fact that the deed of settlement appointed the bank as trustee of the fund for the benefit of the plaintiff and members of his family, the deed of settlement probably did not specify that the fund was to be a special fund and exactly what was deposited was to be returned. Because if you are using an interest-bearing deposit account, the funds in that account is going to be moved in and out. So which means it's going to be changed. So what was deposited is going to be commingled. And what was put into the fund is not going to be the same. So the bank became insolvent. All right? The bank became insolvent. And its license was suspended. So the bank could no longer practice banking because it had no license or it didn't have any permission from the state. A new trustee was appointed. So a new trustee was appointed over the fund. So the issue to be decided was whether the fund could be paid over to the new trustee. So this was the issue to be decided. The issue to be decided was whether the fund that was created by hand with Bank Intercontinental Limited by a deed of settlement could be paid over to the new trustee. Was there a fund? Was there a trust fund for the new trustee to take control of? So this fell to be determined by the true construction of the deed of settlement. And in trust, the instrument, the settler, is the one who creates the laws of the trust. And any breach of trust, or where any doubt is had as to the duties of the trustee or the intention of the settler, the trust instrument is litigated in court, and the judges will determine the intent of the settler based on the deed of settlement or the declaration of trust or the indenture or the trust instrument. So this fell to be determined by the true construction of the deed of settlement. So if the deed of settlement empowered the bank to deposit the trust fund with itself, the new trustee could not recover it in preference to the other unsecured creditors. So the trust fund was unsecured. If it did not, the new trustee could recover the fund. So if the instrument did not empower the bank to deposit the trust fund with itself, the new trustee could recover the fund. However, apparently the deed of settlement did not restrict the bank from depositing the fund with itself, thus creating a debtor-creditor relationship because it was not specific. The fund was not specific. It was an interest-bearing deposit account. So there are interest-bearing deposit accounts and there are non-interest-bearing deposit accounts. All right. It was held that the deed of settlement did confer such a power, and the new trustee was not entitled to recover the fund in preference to the bank's other creditors. And this is why I'm going through this book with you guys, and we're taking our time because I want you guys to get the full comprehension on the principles of trust, so that when we are drafting our own trust instruments and our own trust documents, we will understand that there are certain elements that must be in place in the trust instrument to protect the beneficiaries so that the fund will not be lost from the beneficiaries. All right. So Hall J referred to the judgment of Lord Templeman in Space Investments Limited versus Canadian Imperial Bank of Commerce Trust Company Bahamas Limited, 21, 1986. All right. In which his lordship had pointed out that beneficiaries are not protected against the consequences of the exercise in good faith of powers conferred by the trust instrument. And remember, guys, one of the fundamental principles of a trust is for the benefit of the beneficiaries. All right? So don't take it for granted that if you go to someone to create a deed of settlement or a trust instrument for you, that they will have the benefit of the beneficiaries at heart. And if you don't know the principles of how to properly structure a trust instrument, and someone else structures it for you, you will not be able to see the flaws in it where it leaves the beneficiaries vulnerable. Okay? So the deed of settlement, it left the beneficiaries vulnerable, and they were not protected against a good faith of powers conferred by the trust instrument, because the instrument confers powers, it confers duties on the trustee. All right. So let's see what the Lord Templeman said in Space. He continued, the beneficiaries do not become entitled to an interest in, and then there's brackets, that is, an equitable charge over the bank's assets. An equitable charge also means a lien, meaning that the assets of the bank is held as security for the trust fund. And if the bank misappropriates the trust fund, the beneficiaries will have an interest in the bank's assets and thus be able to recover the trust fund or the value of the trust fund out of the bank's assets. All right. So the beneficiaries do not become entitled to an interest in, that is an equitable charge. So an interest in, that is an equitable charge over the bank's assets. And it does not matter that the bank has placed the money in a trust deposit account. It does not matter that the bank has placed the money in a trust deposit account. Now, a trust deposit account, let's go look at the definition of a trust deposit account. All right? I think I gotta go to deposits. All right, I think I gotta go to deposits. I think I gotta go to deposits for trust deposits. All right, deposits. Deposits. Special deposits. A bank deposit of money that is commingled. Sorry, special deposit. A bank deposit that is made for a specific purpose that is kept separately and that is to be returned to the depositor. The bank serves as bailee or trustee for a special deposit. Also termed specific deposit, time deposit, involuntary deposits. Trust deposit. Trust deposits. Trust deposits. trust distribution, trust deposits. All right. Trust accounts. Client trust accounts. Trust account. See client trust accounts. So you gotta go to C. We're gonna look for client trust accounts. Or trust account, right? So we gotta go to C. Client trust accounts. I much prefer to use the hard copy, guys. But I'm using this because we're doing the video. So you all could see the definitions for yourself. Alright? Alright. Client trust Clifford. Client trust accounts. A bank account, usually interest bearing, in which a lawyer deposits money belonging to a client. Example, money received from a client's debtor from the settlement of a client's case or from the client for later use in business transaction, also termed trust accounts. All right. So a client trust account. So trust deposit account. So that is a trust deposit account, right? So it's a interest bearing account. There is no justification for the intervention of equity because it's general. It's not specific. If it's interest bearing, it's general, meaning that the bank can use the funds, do whatever they want with it, and place whatever percentage of interest into the account. All right. The settler has allowed the trust money to be treated as if it were the customer's money. The settler has allowed the trust money to be treated as if it were the customer's money. And remember, you look up the definition of a customer, right? Customer, one who regularly or repeatedly makes purchases or has business dealings with a tradesman or business house. A buyer, purchaser, or patron, right? So the settler has allowed the trust money to be treated as if it were a customer's money, i.e., or that is, belonging absolutely and beneficially to the trustee bank. And if it's belonging absolutely and beneficially to the trustee bank, what does that tell you? That tells you that the fund or the money having been deposited in an interest bearing deposit account, right? The bank now has title, both equitable and legal title of the funds. So the relationship that was actually created by the deed of settlement that the settler created with his trustees, which was the bank, was a debtor-creditor relationship. He has accepted the risk of the bank's insolvency, meaning that the settler did not protect the beneficiaries by placing an equitable charge on any of the bank's assets. The trust money has become the bank's property to use in any manner that it thinks fit. All right? And this is the wonderful thing about these case laws. We can learn from the mistakes of the people that preceded us. All right, guys? So that is trust distinguished from debt. So just to make it break it down as easy as possible. A trust is in regards to specific property deposited in kind out. All right. Take out a 100 note from your wallet. Look at it. There's a serial number on it, right? If you give somebody that note and tell them that you want this note back with this exact serial number, that is a trust deposit. You just made a deposit to that individual. All right. However, a debt is not in relation to specific property. A debt is in relation to a general debtor-creditor relationship, meaning that if you give someone that 100 notes with the serial number on it, you are only interested in the specific amount being returned, not the specific note. the specific amount. So you will accept 100 in fives, tens, 20s, singles. All right? You will accept the return of your property in that form, in a debtor-creditor relationship, because the debtor-creditor relationship is specific to the amount. The trust relationship is specific to the property. All right? And a debtor-creditor relationship is at common law, and a trust relationship is in equity. A trust is a creature of equity, the exclusive jurisdiction of equity. All right? So that's a trust distinguished from debt. All right, guys. So, all right. So we're gonna stop there for today. All right. We're gonna take it. So we're gonna continue on the next read. I thank you for your time and patience. Check out the trust fundamental terms on my channel so that we can continue learning with the definitions and make it much more clear in the comprehension going forward. All right. Guys, remember, strengthen body, powers, and mind. Stick with me on this journey. At the end of this journey, guys, we're going to come out and be much more knowledgeable on trust and be much more confident and competent in our daily dealings and our daily lives. All right. So stay safe. Remember, I love you guys. Be blessed. Stay up.